of court. Kaya gusto ko pong itama yung medyo hilaw pong interpretation ng ating Honorable Marcoleta. Maraming salamat po, Mr. President.
Noted.
Mr. President, may we recognize Senator Bam Aquino has been waiting for his turn to interpolate the gentleman from Tarlac.
Senator
So
Aquino
moves,
is recognized and may proceed.
Maraming
The
salamat.
gentleman allow it.
Maraming salamat, Mr. President. This is a manifestation, not an interpolation, Mr. President. At kanina pa ako nakikinig.
The gentleman may proceed.
Marami po sa mga puntong nabanggit na ng mga kapwa nating senador ay sumasang-ayon po tayo at tama, no? Napag-usapan na po ang independence ng Senado, kung gaano kahalaga ang papel na ginagampanan natin sa ating bansa, sa checks and balances ng ating gobyerno. At alam rin naman po ng mga kasama natin na sa caucus, sinabi ko rin po na ang posisyon ko ay dapat mag-convene ang impeachment court at doon magdesisyon kung ano ang mga susunod na hakbang pagdating po sa impeachment case. Now, that's known to everyone. I've said that in the media. Mr. President, in our history, nagkaroon po ng mga panahon na ang Senado ay nag-assert ng kanyang independence bilang isang co-equal branch of government. Nangyari po yan many times. I remember in the 90s, kahit po ang executive, at that time, President Cory Aquino, nagnais na manatili ang US bases dito sa ating bansa. Yung Senado, nanindigan, kahit puro kaalyado, kahit puro kakampi at kamag-anak nasa Senado, nag-decide pa rin yung Senate to assert its independence and to do away with the US bases. Nangyari po yan many times in our history, Mr. President. Kaya palagay ko, yung role ng Senado napakahalaga pagdating sa pagpapanatili ng checks and balances. And Mr. President, marami tayong tungkulin. May tungkulin gumawa ng batas, may tungkulin sa pagbuo ng maayos na budget, may tungkulin ng oversight, pero meron din pong tungkulin pagdating sa pananagutan or accountability. At yun po yung sole power to try and decide all cases of impeachment. Ang posisyon ko, Mr. President, at nabanggit rin ito ng iba nating mga kasama, ay mahalagang i-assert natin ang ating independence. Mahalaga po na itong papel na ginagampanan natin sa ating Constitution ay pahalagahan po natin. Mahalaga po na manatili ang independence ng ating Senado bilang isang co-equal branch of government. Mr. President, posisyon ko rin po na nagsimula na ang impeachment proceedings. Nag-robe na po, nagsimula na, merong summons na binigay, may response na po si Vice President Sara. Kami pong mga bago, may mga robe na rin po pero hindi pa po nadudumihan. Hindi po magagamit, no? Ang posisyon ko po, mag-convene ang impeachment court at doon natin i-decide ang mga bagay-bagay na ito. Mr. President, may dalawang bagay rin na nailabas, no? Na hindi pa siguro na pag-uusapan. Let me read, Mr. President, Article 9, Section 3 of our Constitution, Accountability of Public Officers. In case the verified complaint or resolution of impeachment is filed by at least one-third of all members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Wala pong dagdag po dito. No? Dito po sa gallery, kasama ho natin dalawang framers of our Constitution. Nandito po si Professor Ed Garcia at si former Chairperson Christian Munsod. Kanina po, nagbubulungan kami. Sabi ko, nung ginawa nyo to, bakit parang ganun kasimple? Simpleng-simple lang, ito lang. At sabi nga po nila, noon daw, 1/2, 2/3, binabato 1/2 sa deliberation, nag-end up sa 1/3. At yung desisyon ay dahil sa kabilisan. Dahil mahalaga daw na mabilis, pag may 1/3, members of the House ang pipirma, mabilis na pupunta po sa Senado. At ito po, tinatanong ko sa kanila, dahil sila po yung nagbuo ng ating Constitution. You know, many times, Mr. President, umiikot tayo sa ating bansa. I-bring up ko lang po yung free college law. No? Marami ko sa atin dito nagtulungan para sa batas na yan. Meron kaming nakausap na eskwelahan. Ini-explain sa akin yung opt-out provision. Kung paano sila nag-charge ng mga estudyante dahil sa opt-out provision. At sabi ko sa kanila, mali. Mali ang interpretasyon ninyo. Yung interpretasyon ninyo, wala yan sa aming intensyon. Ang intensyon po namin, libre ang kolehiyo sa mga kabataan. At nung nag-argumento po sa akin, ang sabi ko, mas alam ko yan kasi ako ang nagbuo ng batas na yan. Mas alam namin yan dahil kami ang nagsulat ng provision na yan. In the same sense, Mr. President, the framers of our Constitution, mas alam po nila. Mas alam nila kung ano yung intent ng ating Constitution. Wala pong labis, walang dagdag. Many times, Mr. President, tinatanong tayo, usually pag campaign time to, tinatanong kami, Mr. Senator, hindi ba dapat merong educational attainment requirement yung pagiging senador? At sinasabi ko po lagi, wala, kasi wala po yan sa ating konstitusyon. Wala pong dinagdag, wag tayong magdagdag nang wala pong nakasaad po dyan. So gaya po niya, no, binabanggit ko lang po dito dahil na pag-uusapan, may mga dinagdag na mga procedure. Alam ko po, siguro, tama po ang sinasabi ni Senator Marcoleta, baka maganda naman ang intensyon ng Supreme Court. Pero aminin na po natin, wala po yung ibang mga bagay dyan dito po sa ating konstitusyon. Pangalawang punto, ito po hindi rin po nagpag-uusapan pa. Nabanggit po dito, wag na tayong lumaban kasi matatalo rin naman tayo. No? Of course, Mr. President, it is improbable, aaminin ko po yan, very improbable na magbago ang Korte Suprema with 15 votes. But it's not impossible. Improbable at impossible, magkaiba po yan, firstly. But secondly, Mr. President, may mga panahon na kahit alam nating matatalo, kailangan pa ring lumaban. Tayong lahat po dito, dumaan po dyan. Ako po, dumaan rin po dyan. Kahit mukhang mahirap, kahit mukhang matatalo, kailangan lumaban pa rin. Tumayo tayo sa sarili nating paa, mag-assert tayo ng ating independence, ipahiwatig natin yung ating saloobin bilang isang grupo. Ipakita ho natin na co-equal branch of government tayo, na meron tayong punto de vista. At kahit matatalo, kahit sa kaduluduluan ng lahat, rerespetuhan rin naman natin ang Supreme Court, mahalaga na mailagay pa rin kung ano ang nasa saloobin ng ating grupo. Mahalaga pa rin na malagay natin kung ano talaga ang posisyon ng Senado pagdating sa ating independent nature and being the sole authority to try and decide impeachment cases, kahit po matatalo. So para sa akin po, hindi katanggap-tanggap ang posisyon na dahil matatalo rin tayo, huwag na tayong lumaban. Paminsan-minsan po mahalaga na ilagay naman natin ang ating posisyon kahit alam po natin na hindi pabor sa atin ang mga bagay-bagay. Thank you, Mr. President, and we'd like to thank Senator Marcoleta for his time.
Thank you, Senator Aquino. Noted and entered into the records. Senator Marcoleta.
Mr. President, I thank Senator Bam for his manifestation. Totoo nga po na yung binasa niya sa Article 11, Section 3, Paragraph 4, na sinasabi nga naman, in case the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Ngunit, Mr. President, this cannot be applied in isolation of Paragraph 8 na nandito rin po sa the same Section 3, Article 11. Ang sinasabi po sa Paragraph 8, the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. Kaya po ang sinusunod ng House dapat yung rules of procedures in impeachment proceedings. Pero kagaya po na sinabi ko, imbes na sundin po nila, sila po yung gumawa nun eh. Hindi naman po nila sinunod. Kaya po ang nangyari, pinagsabihin ng Korte Suprema, ganito ang pag-file. Nagbigay nga po ng guidelines. Pangalawa po, yung kanyang sinabi na nakapag-umpisa na po kayo eh. Kanina po, kinwalify ko yun before I proceeded in my speech. Sabi ko po, the initial proceedings conducted by the Senate of the 19th Congress were not formally carried over into the Senate of the 20th Congress. Wala po talaga eh. I cannot recall, sabi ko nga, and there is no action taken by this chamber, Mr. President, sapagkat ang alam ko, all these proceedings were already deemed terminated at the expiration of the 19th Congress at noon of June 30, 2025. and they cannot be miraculously bring forth to life. In this Congress, where both of us now belong, because this Congress is of different composition. Yun lamang po ang qualification doon, Mr. President.
Quick rejoinder, Mr. President.
Senator Aquino is recognized.
Yes, Mr. President. Babanggitin ko lang po yung isang na banggit ni my co-gentleman from Tarlac, Senator Marcoleta. Mr. President, may Section 4, may Section 8. Di ba? Ito po ba'y meant to reflect each other or not? Maganda pong matanong yung mga framers of the Constitution. Sila po yung nandoon nung nabuo po ito. At malalaman natin yan kung meron pong oral arguments. Kung ibubukas po ang mga argumento sa publiko, pwede po magsalita yung framers of the Constitution, at doon po sa posisyong yon, malalaman natin ano ba talaga ang intensyon ng mga gumawa ng ating Constitution. And Mr. President, pwede pong mangyari yon if we are able to table this matter and allow for these oral arguments to happen. Mr. President, hindi po ba maganda rin kung ang Senado mismo magsama-sama at magsabi sa Supreme Court, baka magandang magkaroon ng oral arguments dito po sa kasong ito. Yun lang po, Mr. President. Thank you.
So we can continue, Mr. President, with the list of senators wanting to interpolate and make a manifestation. At this juncture, Mr. President, may we recognize the distinguished gentleman from Isabela and Davao, Senator Rafi Tulfo, for his manifestation. So move, Mr.
Senator
President.
Tulfo is recognized for his manifestation.
Thank you, Mr. President. This is not an interpellation, but a short, very short manifestation. In line with what Senator Pia Cayetano said earlier, that we can be creative in our motion today, and correct me if I'm wrong, if I've heard it right, what Senator Pangilinan from the minority said, that we are not defying the decision of the Supreme Court. So may I propose that instead of dismissal, we just dissolve this impeachment court? Because in the first place, per the decision of the Supreme Court, sinasabi na wala naman talaga tayong jurisdiction over dito sa Articles of Impeachment. So mas maganda siguro, i-dissolve na lang natin to para we're still in line with what the Supreme Court said. Thank you, Mr. President.
Noted and entered into the records.
Mr. President,
Majority Leader.
next and last but not the least to interpolate the distinguished gentleman from Tarlac is the lady from Taguig and Pateros, no other than Senator Pia Cayetano. I move that she be recognized, Mr. President.
Senator Pia Cayetano is recognized for interjections and/or manifestation. You may proceed, ma'am, if the gentleman will so allow it.
Yes, Mr. President.
Thank you, Mr. President. With the permission of the proponent, Senator Marcoleta, I would like to
Yes, Mr. President.
make a few observations and then perhaps ask His Honor's opinion on these matters.
Please.
Thank you. So, Mr. President, I'm reading directly from the case Duterte versus House of Representatives. Page 95. It states, the subsequent filing of the Articles of Impeachment under Article 11, Section 3.4 against Vice President Sara Duterte and its transmittal by the House of Representatives to the Senate of the 19th Congress is considered to be a separate and distinct mode of initiating the impeachment process. The Articles of Impeachment are declared barred by Article 11, Section 3.5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. This decision is immediately executory. It shall be deemed served on petitioner and released upon publication the Supreme Court website and receipt of the parties of their digital copy in accordance with AM number 250516 SC, or the guidelines on the transition to electronic filing in the Supreme Court. So, I read this into the record, Mr. President, because I'd like to emphasize a few key phrases. The Senate did not acquire jurisdiction to constitute itself into an impeachment court. I'll start with that one, and then the second one is this decision is immediately executory. So, pag sinabing the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and yet the fact remains that we did constitute ourselves into an impeachment court, then what are we supposed to do? Because the Supreme Court tells us that we did not acquire jurisdiction. As most lawyers, well, all lawyers should know, when the Supreme Court tells another body, usually it's the lower court, or sometimes it's a government agency, and the case was by our accepted rules elevated to the Supreme Court. They tell them you have no jurisdiction. The only thing you do is, what do they call it? There's a term, you have residual powers. And those residual powers basically simply allow you to dispose of the case as per instructions of the Supreme Court. Is that the understanding of His Honor?
Yes, Mr. President. Actually, residual powers apply also under Section 135. Yun po yung sinasabi ko kanina. Hindi ko po sinabi kanina na I am invoking that because the rules of court are there. Hindi po yun. Kasi legislative department po ang sinabi ko doon. Kasi wala pong applicable rules. Pwede po yun, ma'am, Mr. President.
Kasi ang akin po, and I've tried all my life to be a dutiful citizen, and Alan knows I was a good daughter, a better daughter than he was a son, in terms of following our father's rules. Pag sinabing, hindi mo pwedeng gawin yan, wala kang karapatan na gawin yan, hindi ko gagawin yon. At kung ginawa ko yon, babawiin ko. Kasi nga sinabi sa akin na wala akong karapatan na gawin yon. So, yun ho ang iniintindi ko. I am one of 5, tama bang bilang ko, 5 lawyers here in the Senate. And I'm trying to do my job as a senator and as a lawyer. I am trying to listen carefully to our colleagues who have expressed their desire to constitute ourselves as an impeachment court. But I do not know how we can legally do that when the Supreme Court tells us we did not acquire jurisdiction to constitute ourselves into an impeachment court. We did not acquire it then, and we do not acquire it now. So how would we do that? And those of you who've worked with me know how hard I work to find a solution. I bend over backwards, I listen, I redraft everything para masaya tayong lahat. And of course, within the bounds of the law. How do we do that? How?
Mr. President, I think the good senator already provided the answer. By using the Senate's residual power. Kung titignan po niyo yung definition ng residual power, hindi po talaga nakasulat yung power per se. Ngunit inherent sa opisina yon, kaya tinawag pong residual power. Nung sabihin po ng Korte Suprema, this is immediately executory, wala pong ibang departamento, walang ibang opisina ang tinitingnan niya kundi tayo lamang. Kung hindi tayo gagalaw, wala pong iba na gagalaw. At mananatili pong nakahang ang isyong ito, Mr. President.
So, yun yung first point, Mr. President, that I wanted to raise, and thank you for your response, the Senator from Tarlac. And then with respect to the second phrase that I wanted to dive into, immediately executory. So sinabi to dun sa desisyon, and then I think the Senate President mentioned it also, that in their press briefing just yesterday, the Supreme Court stated that, to recall, on July 25, 2025, the Supreme Court granted the petition to dismiss the 4th impeachment complaint against Vice President Duterte. In a 13-02 decision with the justices present voting unanimously, and Associate Alfred Benjamin Kagiwa inhibiting, and Associate Justice Maria Filomena Singh on leave, the Supreme Court en banc ruled that the impeachment complaint was void for violating the 1-year ban and due process requirements. This decision is immediately executory. Inulit pa nila sa press briefing nila. So sa akin lang po, parang nahihirapan ako as a lawyer and a lawyer in the Senate to say that they did not intend it to be immediately executory, because they said this knowing that there already was a motion for recon and knowing that we are going to have this discussion today because we made this date public, that on this day we will have this discussion. So again, I'm trying hard to see how, other than disposing of the case using our residual powers following the instructions of the Supreme Court, we can further debate this issue. That is my dilemma, dear colleagues, Mr. President.
May I offer an answer, Mr. President?
Of course.
Pasensya na po kayo kung gagamit po ako ng paghahalimbawa. Nung pong kayo po ay medyo bata-bata po, Madam Senator, meron pong lumigaw sigurado sa inyo. Yung
Huwag na
unang
ho
lumigaw
natin
sa inyo
pasukin yung
talagang...
diskusyon na yon. Mahaba ho ito, mas mahaba po sa debate ng impeachment.
Ganito po yun eh. Tinapat nyo talaga. Ayaw nyo magtagal pa yun eh. At tama naman po yung ginawa ninyo. Ipinakita nyo sa kanya, pinaramdam nyo sa kanya talagang wala siyang maasahan kaysa mapagod pa siya.
Sino ho
Pero ang
yun?
sabi niya sa inyo, ang sabi po niya sa inyo, pwede bang ako'y kahit papano'y dadalaw-dalaw pa rin? Parang nag-MR. Nasa sayo yun, but that will not change my mind. Ganun din po yun eh. Ang Korte Suprema, sa ganitong, Mr. President, the very tenor of the decision, kahit na po sinabi niyang, oh sige, nasa sayo. Formality na lamang po yun, Mr. President. You are a trial lawyer too. Most of us here became trial lawyers. This is our experience. Huwag po nating pahirapan yun. Sana man lang kung ang decision po 8-7. Yun po pwede nating pagtalunan po eh. Wala po talaga eh, Mr. President.
If I may, Mr. President, and I think that was a good analogy. Thank you for that. Napaisip niyo ho ako doon. I think what's interesting with His Honor's analogy is there are people, there's the public, I don't know, millions of people would like to understand ano ba yung final na kasong yun, may evidence ba? And totoo yan, di ba? Hindi natin matatanggal yun. So in the same way, yung manliligaw na walang pag-asa, gusto din niyang malaman na ano ba yung chances, ano ba yung nangyari, bakit ba meron kang ganitong conclusion, can I convince you otherwise? I think that's what His Honor is trying to say. And I think the public really want to know. Let the record show na tawang-tawa po si Senator Bato sa likod. And we really want to know, sino ba namang may ayaw malaman kung merong isang public official na naakusahan ng katiwalian? Lahat po tayo interesado doon eh, whether mahal mo yung taong yon, whether galit ka sa taong yon, you want to know the truth. Kasi kung naniniwala ka na innocent yung taong yon, gusto mong mapatunayan niya na innocent siya. At kung galit ka sa taong yon, gusto mong mapatunayan na guilty siya, hindi ba? But meron tayong kinikilalang Supreme Court na nagsasabing hindi nga dumaan sa tamang proseso. So kumbaga siguro sa example nyo, baka hindi dumaan sa tatay ko, hindi nagpaalam ng maayos. Di wala naman akong choice, kundi sabihin na wala kang pag-asa. Baka naman may pag-asa, pero I have to follow the rules of my father's house na hindi dumaan sa tamang proseso. So doon ho tayo babalik, and as a lawyer, I have to say this na yun nga, we are governed by laws. And in as much as gusto ko rin malaman, bothered ho ako sa mga gantong okasyon. The other day, our colleagues, merong privilege speech tungkol sa kalokohan dun sa paggagawa ng mga flood control. Gusto natin malaman, di ba? Ngayon, pagka yun na-discuss sa sa media, okay na, media siya. Pero walang papupuntahan yun kasi it should go to the proper process. May process yan sa halls of the Senate. We have hearings in aid of legislation, and then magre-recommend tayo na ma-ombudsman yan. So may proseso tayo. So yun ho siguro yung pinapatunguhan. Doon ho papunta ang aking conclusion na in as much as the public deserves to know, because we all deserve to know. We also have to follow the process. And I share this with everyone kasi ang hirap lang talaga ng sitwasyon natin kung hindi tayo makikinig sa Supreme Court. Meron tayo in the Senate, Congress, we have our duties as co-equal bodies. Ang duties po namin kasama ang pagsiyasat ng budget ng lahat ng agency. So pati Supreme Court, budget niya, tinitingnan. Lahat ng Regional Trial Court, tinitingnan natin ang budget. That's our job as a co-equal. Sila naman, may job din sila na pagka may grave abuse of discretion, they have to also say it. They also have to make their position known, which they have. And I will repeat, ang sabi ng desisyon ng Korte Suprema, the Senate did not acquire jurisdiction, and this decision is immediately executory. So, I'm happy to listen. I don't know kung may magsasalita pa, pero I shared my views on this in the hope na marinig ko din yung views ng proponent. Nakikinig po ako sa mga kasamahan natin para ma-enlighten din po ako. But I'm guided also by my practice as a lawyer and my duty as a lawyer to also, I can disagree with the court. Wala tayong problema doon. We know that we have that personal right to disagree with the court. But we also have to, in the end, follow the court's orders, whether we agree with them or not.
Very quickly,
Thank you, Mr. President.
With the permission of Senators Marcoleta and...
What is the pleasure of Senator Pangilinan?
Just a quick interjection.
The gentleman may proceed.
Maybe to add to either the enlightenment or additional bewilderment of Senator Pia Cayetano. Yes, the Supreme Court ruled that we did not have jurisdiction. Yes, the Supreme Court ruled that it is immediately executory, but it makes you wonder why the Supreme Court did not issue a writ of injunction. So
Did not, sorry, I didn't hear that. It makes
did
you
not
wonder
issue-
why.
Did not enjoin us, did not issue a writ. It could have, but it did not. So, yeah, your guess is as good as mine, because if they really wanted us to end this, then why didn't they enjoin us?
Just to add to the bewilderment and the enlightenment, what is there to enjoin when we never acquired jurisdiction according to them? What is the pleasure of the Honorable Ontiveros?
Thank you, Mr. President. Dalawang dagdag na punto lang para sa diskusyon natin. Precisely regarding the immediately executory na kababanggit lang ni Senator Pangilinan at inulit din kanina ng good gentleman from Tarlac at pati ng good gentlewoman from Taguig Pateros, immediately executory. Still, Mr. President, there is no defiance here dahil the ruling, hindi pa rin po final siya. And even if the ruling states that it is immediately executory, at kahit inulit po yon dun sa recent na anunsyo ng Korte Suprema tungkol sa MR, even if the ruling states that it is immediately executory, the court itself in many cases has explained that this does not mean self-executory. Immediately executory does not mean self-executory. Section 1, at ito taugnay ng kasasabi ni Senator Pangilinan, Section 1, Rule 39 of the 2019 Rules of Court states that execution shall issue as a matter of right on motion. This means that a writ of execution issued upon a motion is necessary for the execution of a decision. At this point, Mr. President, wala pa pong iniuutos ang Korte Suprema sa Senado. And secondly, at this point, Mr. President, bukod pa po kasi sa yung first group of complainants, yung House of Representatives mismo sa pamamagitan ng Solicitor General at yung isang bayan, meron pang isang importanteng entity, institusyon sa ating lipunan na nagsalita tungkol doon sa Supreme Court ruling. At ito po ay isang entity sa mass media, ang ABS-CBN. meron po silang anunsyo, ABS-CBN news statement on articles cited in the Supreme Court decision on Vice President Sara Duterte's impeachment. At gusto ko lang i-make of record dito, Mr. President. Sabi nila, ABS-CBN News respectfully clarifies that the article cited in the Supreme Court decision on the impeachment of Vice President Sara Duterte did not state that the House of Representatives transmitted the articles of impeachment to the Senate without a plenary vote. The ABS-CBN statement, Mr. President, calls into question the factual premises of the SC decision. Isa po ito sa binabanggit na numerous factual errors. If the very factual premises were wrong, the legal conclusion cannot be relied upon. With due respect, salamat po, Mr. President.
Majority Floor Leader.
Yes, Mr. President, last but not the least is a quick manifestation from the distinguished gentleman from Palawan, Senator Erwin Tulfo. I move that he be recognized, Mr. President.
Senator Erwin Tulfo is recognized. You may proceed, sir, if the gentleman will so yield.
Yes, Mr. President.
Ginawang Pangulo, bilang bagong senador, ako po ay nais ko pong maliwanagan dahil kanina pa po ako nagugulamihanan sa mga pangyayari. Dahil 3 motion po ang nakasala ngayon, motion to dismiss, motion to table, motion to archive. Yung pagkaintindi ko po ngayong araw, dalawa lang po ang ating pagdidesisyonan. Kung tayo ay i-dismiss na natin ito, o tayo po ay magkakaroon ng trial. At nag-aantay po ang taong bayan. At lumalalim na po ang gabi. Kaya ang tanong ko po ngayon, are we actually going to vote later or sa ilang saglit? At ano po ang ating pagbobotohan, Ginoong Pangulo? Yan lamang po.
To answer the query of the good gentleman, there are only 2 pending motions. The motion to table by the distinguished Minority Floor Leader, which has precedence over the earlier motion of Senator Marcoleta, supposedly to dismiss, but that he acceded to amend it accordingly, and he will state the motion before we put it to a vote after we dispose of the motion of the Minority Floor Leader to table. So dalawa lang po yung pagbobotohan at dahil sabi ng kagalang-galang ng puno mayoriya na kayo na po yung huling magmamanifest, tutungo na po tayo doon.
Maraming salamat po.
With that, Mr. President, and no member wishes to interpolate. The minority leader is also seeking the floor. I move that he
The
be
Minority
recognized,
Leader
Mr.
is
President.
recognized. What is your pleasure, sir?
Thank you, Mr. President. Just one last push, so to speak.
The gentleman may proceed.
We're not saying that we defy the Supreme Court decision. We're simply saying, wait. Patience is a virtue. Yung analogy kasi na sa panliligaw, dismiss mo na kagad. Although merong mga matintimang birheng bumigay. Mas magandang analogy ito, Mr. President. In a basketball game, crucial, finals, world championship, merong review ng foul ang referee. Review muna. Dahil may foul eh. Ang gusto ng isang team, maglaro pa rin kahit nire-review. It's as simple as that. So, why not listen to the possibility of not dismissing but not accepting to table. And then we can bring it out anytime. Again, dun sa sinasabing Supreme Court has never considered a unanimous vote. It has. And the Supreme Court also spoke. Sabi nila, the immediately executory, they are not considered final until the lapse of the prescribed period without a so and so and so. Supreme Court din mismo may sabi niyan eh. Yun lamang po. Hopefully, kung speculation ang pinag-uusapan natin, stating that the Supreme Court will not reverse its unanimous decision is also speculative. So, pagbigyan natin to, Mr. President, sunod tayo, pero ilagay naman natin sa lugar. Medyo, ang Senado naman dapat itaas natin ang integridad, reputasyon. Hindi tayo, pag sinabi tumalon, tatalon. Pakinggan naman natin muna dahil maraming mali Maraming error ang House, may error din yung Supreme Court decision, obviously. So you cannot right a wrong by another wrong. Thank you, Mr. President.
Noted. Senator Allen.
Mr. President.
Mr. President. Mr. President.
Yes, Mr. President.
So, I'm discussing with the minority leader, trying to pursue a wording that will articulate our collective intent of the Senate. May I just mention and have a few, maybe 2 minutes with what Senator Risa, the esteemed senator, said. Yung spirit kasi ng Constitution, once ka lang pwede ma-impeach sa 1 taon. At very clear po, pati po yung esteemed, I do recognize our the former chairman of the COMELEC, who, if he did not qualify me, I would not have become a councilor. Christian Munsod, our esteemed legal luminaries are here po. Alam nyo po, in all the books nakalagay doon, bakit may 1-year ban? Kasi nga, hindi daw dapat guluhin ng guluhin yung impeachable officer all throughout the year. Dapat isa lang. So yung spirit ng decision, nung sinabi ng BARD na, bigyan mo siya hanggang 1 year, hanggang February 6. Pero lumabas tayo sa legal. Ipa-floating muna natin to. I-dribble muna natin, tignan muna natin. When is the soonest that the Supreme Court can decide? The next 15, 30 days? By September 1, simula na ng budget hearing sa House. By late September, simula na tayo sa Senate. Baha, DepEd, gamot, trabaho, lahat yan, inaasikaso natin. Kung walang choice at isasabay natin impeachment hapon, impeachment umaga, legislation, bakit hindi? Pero hindi ba dapat bigyan din natin ng katahimikan yung ating bansa at least until February 6? Na sinabi na ng Supreme Court, barred, mali ang proseso, tuldukan na rin natin sa Senado. So, ang isa na lang po ang pinag-uusapan natin, which I want to give honor and thank the minority leader na, pero may appeal. So, whether or not the Senate says tuldukan na natin, nandun pa rin sa Supreme Court yung appeal. Would it be acceptable both to Senator Marcoleta and to the minority? What if we word the motion that we move to adhere to the decision of the Supreme Court in Duterte versus period? Huwag na natin ilagay sa dulo kung dismiss area. Merely adhering. Kasi nasa decision naman, nasa loob na naman decision na void ab initio and executory right away. So I don't know if that's acceptable. No? I'm trying to think of a word. Adhere, even obey kasi baka ma-misinterpret na because some of us say na wala tayong choice to obey, some think na wag tayo subservient, di ba? But adhere might be a good word. Senator Marcoleta, are we getting closer or medyo lumayo?
I think, Mr. President, we're getting closer, except that we should put some operative words there that would indicate the closure of this very issue.
Mr. President, what if it's we move to for the Senate to adhere to the Senate to the Supreme Court decision in Duterte versus House of Representatives and hereby terminate whatever unless or until certain time na may. Mr. President, may I ask the good sponsor, can we mention the appeal?
I don't think so, Mr. President. I think we can only
Because
adhere.
it's immediately executory.
I think in obedience to the decision of the Supreme Court, the Senate adheres to it and put to rest.
Let me put it another way, Mr. President. If a motion is approved to act upon the decision and to adhere to the decision, am I correct, Mr. President, that that will be the decision, that will be in our journal, and then by operation of administrative process in the Senate, everything that has to do with the impeachment will be sent to the archives?
That is correct, Your Honor. That is the
Yeah, I yield to
administrative procedure
Yes.
that will logically follow.
I yield to my colleagues, Mr. President. I'm just trying to
Senator
come up
Zubiri
with a
is
consensus.
recognized.
Mr. President, I think the operative word today, if we do decide to act on the matters, to archive, as the precedents with former Ombudsman Gutierrez and former Chief Justice Davide. My
No,
question is,
former President Estrada.
former President Estrada, my apologies. Today, one of our Senate resolutions was archived. This is resolution number 35. And it's really simple, a simple amendment to the rules. But my question, Mr. President, is nothing can stop us from pulling it out of the archives and taking it over once again in plenary. Is that correct, Mr. President?
That is correct, Your Honor. Besides, although the Supreme Court said that the Senate never acquired jurisdiction and that the articles of impeachment are void, null and void ab initio from the beginning, we cannot deny the fact that the articles of impeachment were in fact sent to the Senate, that the Senate convened and sent out certain orders and summons, and these are all part of the records. So it's but natural, although it was declared unconstitutional and that the Senate never acquired jurisdiction, for us to still include that as part of the records of the Senate, because it is part of the Senate's history.
Yes, and precedence tells us that we have done so in the past.
That is correct, Your Honor.
So, would it be proper to say that it will be archived without prejudice to the decision from the final decision of the Supreme Court from the motion for reconsideration? I mean, it's the same thing, without prejudice. We do that with the bills. We approve it on second reading without prejudice, but each and every one of us here questioning second reading approval, they have 3 days in which we can act upon it.
Well, Your Honor, whether you state that or not, we can bring it out of the archives by a majority vote anyway. So it's at the
Yes.
pleasure. It's with the pleasure of the body if
Yes.
the body will agree to include that phrase or not. But
Thank you
in
for the
relation to
clarity,
Senator
Mr. President.
Cayetano's suggestion, Senator Marcoleta, if we simply vote in your case, not the motion to table, to adhere, once that decision becomes final, meaning to say after the lapse of the period for a member who voted with the winning side, on the winning side, to seek a reconsideration, the natural effect, without being included in your motion today, would be to archive it. And by virtue of the manifestation of former Senate President Zubiri, if circumstances change, nothing prevents the body, plenary, from making the corresponding motion, putting it to a vote, and reflect the change in circumstances, if any.
That will be acceptable, Mr. President.
Thank you, Your Honor. Senator Soto?
Mr. President, somehow parallel to what you're discussing, perhaps you could consider, no, and I would like to call the attention of the original proponent of this position, Senator Alan Cayetano, who was former Speaker of the House, to adhere to the Supreme Court decision upon its final disposition. In meantime, table or archive upon whatever your pleasure would be. At least, maliwanag sa atin na upon its final disposition, na may motion for reconsideration, we're still giving that chance of a motion for reconsideration.
If I may, Your Honor, if you will indulge me, if I may state the working motion to adhere to the July 25, 2025 decision of the Supreme Court declaring the Articles of Impeachment null and void ab initio, and that the Senate did not acquire jurisdiction over the same. We can stop there. And then, as I said, after the vote becomes final, on Monday or Tuesday, if no one will seek a reconsideration, to archive it. If there is no change, then it remains in the archives and nothing needs to be done. If the Supreme Court reverses itself, however possible or impossible that may be, then we will entertain a motion to bring it out of the archives. Bring it out of the archives and act accordingly again in obedience to the Supreme Court decision. So,
Ang problema, Mr. President, when we say that the Senate has not acquired jurisdiction, masang-ayon tayo sa sinasabi ng Supreme Court decision nilang ito na maraming nagsasabi na hindi tama. Dahil tinawag nyo to ng June 9 nag-oath ang Senate President. Nag-oath yung iba ng June 10, nag-motion, nag-robe pa nga Hindi naman pwedeng pampelikula lang yun, pan-TV lang yung robe na yun. You convened. So hindi pwedeng sabihin ng Supreme Court that you never acquired jurisdiction. February 5, 4:15 p.m., the Senate President's Office and the Senate Secretary has received the Articles of Impeachment.
I'm sorry, Minority Leader. Legally, when you say the Senate never acquired jurisdiction, it does not deny the fact that we convened. That is a totally different matter. It says that since the Articles of Impeachment violated the one-year ban, that we never supposedly acquired jurisdiction. Not that we never did when it was not yet barred by the Supreme Court. That factual situation still exists and is part of our records. As I said, that's why the better alternative is to archive it, because it was part of what actually happened, transpired, and it's part of the Senate's history. But having said that, without belaboring the point, if agreement cannot be reached, then we can proceed to dispose of the motion of Senator Soto, our distinguished Minority Floor Leader, to lay the motion of Senator Marcoleta on the table, and depending on the outcome of that vote, should it not be favorable to the movant, then we proceed to act on the motion of Senator Marcoleta. If it is favorable to the movant, the distinguished Minority Floor Leader, then there is no need to proceed with the motion of Senator Marcoleta. Senator Lacson.
Mr. President, we have to determine first if Senator Marcoleta has legal standing in filing his motion to dismiss.
He will amend this motion later. We will first decide on the motion.
So there's amendment to the motion.
Yes. And then let's hear his motion, Your Honor.
Yes. Mr. President, the lady from Antique is seeking the floor. I move the TB.
Senator Duterte is recognized. What is your pleasure, ma'am?
Thank you, Mr. President. It's been 3 hours and a half with the very enlightening discussions. I just wanted to clarify, and actually, may I convey that there is a sliver of a difference between the two motions, so I wanted to be clarified. The original motion to dismiss, I believe, has been amended based on the discussions to the motion to archive.
Yes.
And the motion to archive, in my understanding, based on all the explanations, would be without prejudice to the reopening of the possibility after the Supreme Court conveys its ruling on the motion for reconsideration.
Yes.
And therefore, in the possibility of the event that it reverses itself, then we would act accordingly.
That is correct.
On the other hand, there is a motion which takes precedence, and that has been the motion of the Minority Leader to lay on the table the motion. But when you see and interpret the amended motion of the original movement, Senator Marcoleta, and the Minority Leader's motion, it's similar because it lays on the table, or it somehow just postpones indefinitely until such time that the Supreme Court has decided on the motion for reconsideration. Is there any possibility that
May
we
I
can
explain the
agree so that we can amend it so that the body can actually vote as one? Because we are not putting it to a permanent halt, because we will be waiting anyway for the motion for reconsideration by the Supreme Court.
Yes, Mr. President.
The ruling on that.
May I have
Yes.
1 minute to explain the difference?
I know that there is,
Yeah.
let me state, I know there is a difference. I was just trying to bridge
Yes.
the difference so that there is no need for a painful vote.
Yes, I will just explain the
yes.
difference so that we
Senator
know.
Cayetano is
Yes.
recognized with the permission
Yes.
of Senator Intulfo.
Thank you. Mr. President, the reason why I want to explain the difference, para malaman natin bakit malapit pero malayo.
Yes, okay.
Because when you laid it on the table, ang ibig sabihin niyan, buhay pa yung impeachment. Samantalang ang sinabi ng Supreme Court, immediately executory. So pag lay on the table, buhay pa yan, pero mamamatay yan paglabas ng MR. Pag in-archive mo, baliktad. Patay na yan. Kasi sinabi na ng Supreme Court, immediately executory.
Void ab initio.
Pero mabubuhay yan pag binuhay ng Supreme Court. Now, ang ibinigay na po ni Senator Marcoleta sa atin, pumayag na siyang tanggalin yung word na dismiss. Because nga, even I question, we're going to dismiss, wala nga jurisdiction. Although there's a Supreme Court ruling saying na pag wala ka na magawa, walang jurisdiction, i-dismiss. So the proposal, which is accepted by Senator Marcoleta, is that we adhere to the decision and then archive it. So ang natural effect nun, sinunod natin yung Supreme Court na immediately executory. Wala tayong, we cannot say na tama to, malito, malito. You only have two choices. Do you follow the Supreme Court or you don't follow? You cannot say tama to, malito. So that's I think that's the level of disagreement.
Okay, I
Mr.
take
Chair.
note of that, and I was trying to have a unanimous vote and trying to bridge the two motions, which, based on Rule 31, there is actually no motion to archive, but actually every day we archive in our referral. So because of that practice, then that motion is therefore acceptable. Having said that, Mr. President, let me just summarize what we are voting on. We're actually, and I will just say it, the very, very short dispositive portion of the Supreme Court decision. And this is the article, and I quote it, the articles of impeachment are declared barred by Article 11, Section 3, Paragraph 5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and this decision is immediately executory. I just wanted to summarize what we've been discussing for 3 hours and a half. And while my attempt to bridge the two similarly worded motions did not succeed, then we will therefore have to put it into a vote. Thank you, Mr.
Majority
President.
Thank you,
Leader.
Mr. President. Mr. President, I think we heard enough, and I think it's about time that we dispose the motion of our distinguished minority
Mr. President,
leader
Mr.
to
President.
lay this on the table, Mr. President.
President,
So
parliamentary
I move
inquiry.
for the previous
Parliamentary
motion.
inquiry, Mr. President.
What
Mr.
is
President, Senator Aquino is seeking the floor.
What is the parliamentary inquiry of Senator Aquino?
Mr. President, may I get, earlier Senator Cayetano talked about the differences between a motion to table and motion to archive. May I get an official response, Mr. President? Is that really the difference?
Your Honor, we have not yet heard the motion of Senator Marcoleta.
No, Mr. President, a motion to archive and a motion to table, for us laymen, it sounds similar. Sa totoo lang, Mr. President. Anong pinagkaiba niya, Mr. President?
Senator Aquino,
I mean,
what Senator Soto, that's why I prefer that we act on the motion. What Senator Soto is seeking to table is not the articles of impeachment nor the impeachment case, but the motion of Senator Marcoleta, which we haven't heard.
Okay.
So, when we decide on the motion to table, the motion of Senator Marcoleta, not the articles of impeachment.
Yes. And the motion to archive are the articles of impeachment, Mr. President.
Yes.
Yun yung pinagkaiba niya.
Yes.
Thank you, Mr. President.
Senator Soto?
My motion to table was to table the motion of Senator Marcoleta.
Yes.
The
That's
motion
exactly
to
what I
dismiss.
said, Your Honor.
Yes.
Oo.
That's exactly what I said.
That is
That
not,
the motion to table pertains to the motion of Senator Marcoleta,
to dismiss.
not
Correct.
the articles of
new one.
impeachment.
Articles.
The motion of Senator Marcoleta, if at all, would pertain to the articles of impeachment and or the impeachment case.
And if I may add, Mr. President.
Senator Pangilinan?
Well, the motion to archive.
Senator Pangilinan, we're not yet there.
Well, okay. The motion to table, the motion, then frees us from the debate of whether or not we have the power as a Senate in plenary to address the impeachment complaint.
The chair said that earlier.
Yes, and therefore
We will first
Okay.
put to a vote the motion to table of our distinguished minority floor leader, which under our rules has precedence over the motion of Senator Marcoleta, although made earlier. Depending on the outcome of that vote, then we will act on the motion of Senator Marcoleta accordingly. Senator Estrada.
Mr. President, we have been listening to all the manifestations of almost all senators who stood up. Mr. President, it has been 4 hours listening to several manifestations of our colleagues, and it is about time that we decide right away the pending motions before us. Mr. President, the Filipino people are watching. The Filipino people are listening. The Senate has to act, and the Senate has to act decisively. Thank you, Mr. President.
Thank you, Mr. President. I move for the previous motion, Mr. President. On the motion of the Minority Leader, Senator Tito Soto, to lay on the table the motion of Senator Rodante Marcoleta.
Is there any objection to the motion of the Majority Leader for the Senate? What is the pleasure of the Minority Floor Leader?
Mr. President, I move for a nominal vote.
The chair has every intention of doing that, Your Honor. There is a motion to vote on the motion of Senator Soto to lay on the table the motion of Senator Marcoleta pertaining to the articles of impeachment vis-a-vis and in light of the Supreme Court decision of July 25, 2025. To explain, a yes, affirmative, or aye vote supports the motion of the Honorable Minority Leader, and it therefore means that we will not act on the motion of Senator Marcoleta today. A nay vote, a no vote, means that the motion of Senator Marcoleta will not be laid on the table and that we will act and vote upon it today. Senator Lacson? Later on, we'll know the amendment. Senator Lacson, so that it's on the record, please.
So you're only referring, Mr. President, to the motion to dismiss? No, motion to table. Just the motion to table.
Just the motion to table, Your Honor, because we are not yet there. There being no objection, the motion is of the... Yes, Senator Zubiri.
Yes, Mr. President, being a former Senate President and being former Majority Leader, I'd like to ask the audience to restrain from commenting or laughing, please. Well, we are in a, for me, it's a sacred place. It is in the august chamber of the Senate that we have decorum. May we ask for decorum from those who are watching within the plenary, Mr. President.
Actually, they have been silent for the past 3.5 hours. Chair would like to remind the people in the gallery to kindly respect the processes and procedures of the Senate and to avoid any claps, any jeering or comments so that we can proceed with roll call vote.
Yes, with due respect, because I heard a lot of laughing after the poor gentleman from our good friend, Senator Lacson, asked only for a clarification of the vote that will happen in a few seconds.
The Sergeant at Arms is so directed.
Just proper decorum, because this is a very important vote, and it's a very serious vote that will be taking place. Thank you.
The Sergeant at Arms is so directed to kindly maintain order in the gallery. Acting now on the motion of the Majority Leader for us to divide the House and vote on the motion to lay on the table, Secretary is directed to call the roll for nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan. Senator Cayetano Pia. Senator De La Rosa. Senator Ejercito. Senator Estrada. Senator Gatchalian. Senator Go. Senator Ontiveros. Senator Lacson. Senator Lapid. Senator Legarda. Senator Marcoleta. Senator Marcos. Senator Padilla. Senator Pangilinan. Senator Soto.
May I register my vote, Mr. President?
The Minority Leader may proceed.
Thank you. Mr. President, the Supreme Court decision is now pending appeal. It is prudent to wait for the results rather than prematurely archiving, if not dismissing, because I know for a fact, once it is archived, it is dead. So what happens if the Supreme Court reverses itself? Clear and blatant errors are present in the ruling of the Supreme Court. First, they misunderstood the legislative process in assuming that the 19th Congress adjourned sine die in February 5. Grave error. Thus effectively dismissing the first three complaints, paving the way for them to say na ano pala, yung 1-year ban binayolate. The archiving of the three complaints were done after the initiation of the fourth complaint. The 1-year ban did not set in. Second, the decision practically amended the clear mandate by the Constitution by placing a hierarchy on the modes to initiate an impeachment complaint. Parang wala na yung third option. Third, the Supreme Court retroactively applied the new definition to the present case in the violation of the doctrine of operative facts, thus voiding as well the impeachment proceedings of former President Estrada and Chief Justice Corona. They did not interpret the Constitution, Mr. President. They amended the Constitution. So lastly, the Supreme Court now has the chance to rectify these errors in its decision. So I was hoping to table the motion so that we can let us afford them this opportunity for the benefit of future impeachment processes and to uphold the clear mandate of the 1987 Constitution. All we needed to do was wait a little. And so I will have to register a yes vote. I know it will be a vote in the minority, but I have always voted in the minority in many issues in the Senate since 1992 up to the present. Always prayed I was wrong. Unfortunately, I was always right. My God, have mercy on your decision. I vote yes.
Noted. Secretary will please continue.
Senator Tulfo Erwin. Senator Tulfo Rafi. Senator Villanueva. Senator Villar Camille. Senator Villar Mark. Senator Zubiri. Senate President Escudero.
No.
Pwedeng mag-explain ng boto.
Before the explanations of vote, Chair would first like to make of record the result. With 5 affirmative votes, 19 negative votes, the motion to table the motion of Senator Marcoleta is lost. Lost. Soto. Sorry, Senator Soto is lost. No, he said the motion to table the motion of Senator Marcoleta is lost.
Yes.
Pati tuloy ako, nalito dito siya.
Mr. President,
Senator Villanueva.
If I may, Mr. President, and to go back to the first motion raised by Senator Marcoleta. If I may be allowed, Mr. President, to amend, Mr. President, the motion, Mr. President.
The gentleman may proceed with the permission of Senator Marcoleta.
Mr. President, adhering to the immediately executory decision rendered by the Supreme Court en banc on July
Executory. We in the Senate are stewards of the Constitution and the rule of law. Our fidelity must be strongest precisely when institutions are under strain or pressure. To proceed as though the ruling were uncertain or optional would be a departure from our constitutional duty. This manifestation is a commitment to respect the present authority of the court's decision while remaining open to its final word. I cast my vote without prejudice to the Supreme Court's disposition of the pending motion for reconsideration. The court speaks, and at times it speaks again. But until it does, the Senate must not act contrary to what it has already said. For these reasons, I vote yes. I honor the decision of the Supreme Court. Thank you, Mr. President.
Thank you, Senator Legarda. Mr. Secretary.
Senator Marcoleta.
Senator Rodante Marcoleta is recognized to explain his vote.
Ginoong Pangulo, noong ang ating Panginoong Diyos ay nilalang po niya yung unang dalawang tao, pinagsabihan niya rin po meron siyang isang sinabi sa kanila na para na rin po sa kanilang kapakanan. Ang sabi po niya, kayong dalawa, lahat ng nakikita ninyo na bunga ng halamanan sa inyong paligid at lahat ng mga hayop na nakikita nyo na gumagala riyan, pwede ninyong kainin para sa inyo lahat yan. Ngunit yung natatangi na puno na nandiyon sa gitna, ay huwag ninyong gagalawin. Matatagpo ang kabawalan ng ating Panginoon Diyos. Kaya lang po, mayroon pong isang ahas na biglang nakialam. Sabi niya dun sa babae, sinabi ba ikaw ng Panginoon Diyos na pagka kumain kayo dyan sa bunga nung nasa gitna na yun, ay kayo mamamatay? Oo, sabi ng babae. Hindi totoo yun. Ang totoo niyan, pagka kumain kayo dyan, mas lalo kayong tatalino. Ito naman si babae, Mr. President, nakinig. At nung makinig siya, pinuntahan pa niya yung asawa niya. Yun po yung kauna-unahang under desire po, Mr. President. Napakain din po yung asawa. Ano po ang ibig ko sabihin? Bakit ko po nilalahad ang pangyayaring ito? Meron na pong kapasyahan Ang dami pong gustong sumausaw, ang dami pong gustong magsabi ng kaibayong pananaw at paniniwala doon sa kapasyahan na iginagalang nating lahat. Ang ibig ko po sanang sabihin, magpakaingat-ingat naman tayo kung sino-sino na lang ang nagpapayo sa atin. Kung mapapansin po ninyo ang karamihan ng nagpapayo na yan, may pagkakatulad po silang lahat Una, lahat po sila hindi nila binasa ng kumpleto yung rules of procedures ng impeachment proceedings sa House of Representatives. Sapagkat kung binasa po nila yon, malamang hindi po ganun ang kanilang ibinubulong. Pangalawa, lahat po nung yun ay puro paborito po ng mainstream media. Sila na lang po yung tinatanong Pangatlo, lahat po ng yun, walang pagmamahal sa mga Duterte. Ngayon, kung yung kalipunan po ng mga tao na yun, ng karamihan po sila, sa kanila ay nagsasabi, sila po yung mga legal luminaries. Tingin ko po sa kanila, yung iba ay legal mercenaries, Sir President. With all due respect to the word. Kaya po kung minsan, imbes na po malinawan ang marami po nating kababayan, nagkakaroon po ng pag-aalinlangan. Yung iba po ay naililigaw, nalilinlang sapagkat iba't iba. Kaiba yung mga paniniwala, pinipilit at gustong ipilit na yung pa yung mananaig kesa dusang kapasyahan na po na ibinaba ng Korte Suprema. Kung sa bagay nga po, sa una ko pong paghahalimbawa, Panginoon Diyos na nga po yun kinontra pa ng ahas Ginoong Pangulo, sa mga abogado po, palaging may biruan Kasi po, sa lahat ng pagdidiskusyon ng ating korte, lalong-lalo na po ang kataas-taasang hukuman, hindi naman po lahat ay agreeable. Merong partidong aggrieved siya, merong partidong masaya siya. Ngunit, sa katapos-tapusan wala po tayong magagawa kundi tanggapin ang kapasyahan. Minsan po sinasabi nga natin kahit pabiro, alam mo ninyo basta desisyon ng Korte Suprema ay nagiging bahagi ng ating mga batas, maliman o tama. Yun po ay nasa Article 8 Civil Code na binanggit na po kanina ni Senator Bato. Nang sinasabi po, judicial decisions applying or interpreting the laws on the Constitution shall form part of the legal system of the Philippines. Wala na po tayong magagawa doon. Batas na po yun Sa akin pong naunang talumpati kanina, Ginoong Pangulo, hindi ko na po ulitin. I will just request that my entire speech, Mr. President, be incorporated by way of preference to be included in this explanation in my voting yes for my own motion. Thank you very much, Mr. President.
Thank you, Senator Marcoleta, for your explanation. Madam Secretary.
Senator Marcos.
Senator Amy Marcos recognized to explain her vote.
Thank you very much, Mr. President. I vote a resounding yes. Sa hinaba-haba kong pagsisilbi sa Kongreso, sa 12 taon na nanilbihan kami, ang trabaho ng kongrestista, sa pagkaalam ko, ay maging kinatawan ng kanilang distrito o kanilang sektor. Bakit naman ngayon ay naging tagabantay na lamang sila ng humihiyaw na dambuhalang sanggol? Ginawa ng bonjing na armas ang impeachment. Ang dating para sana sa kaayusan ng sistema, ginagawang pampagulo, panakot at sandata laban sa mga kinaiinggitan, kinaiinsecuran ng mga lulong sa kapangyarihan. Galangin naman natin ang Korte Suprema. Huwag tayong umastang Supremer Court. Supremest pa. Wala namang ganun Sa mga kapatid kong senador, paano tayo magiging dakilang mambabatas kung tayo mismo ay hindi susunod sa batas? Ang boses ng Korte Suprema ay boses ng konstitusyon. At kung sino man ang sasapaw sa boses na ito ay isa lang ang tono, ambisyon. Kaya naman, mag-move on na tayo. Magtrabaho at huwag konsentihin ang isang spoiled na bonjing. Huwag nang busugin ng pabor. Huwag nang pumayag dahil may pabuya. Huwag tayo magpalaki ng buwaya, baby pa nga ang tawag, lulong na. Sa mga mahal kong kongresista, may suggestion po ako. Ito, suggestion lang naman, Huwag niyong masamain. Kesa inaatupag ninyong palitan ang pinili ng taong bayan, binoto at minahal. Bakit di nyo nalang palitan ang tao, kayo naman lang ang pumili? Ayaw paawat ng iba sa kaka-flex. Ano kaya kung yung speaker nyo na lang ang paltan nyo? Kaya nyo yan. At dahil dito, bumuboto ako ng malakas na oo. Maraming salamat po.
Thank you, Senator Amy. Before the Secretary recognizes the next Senator, who are these people almost creating trouble there? Can you please trace their identities and send them out of this building. Secretary.
Senator Padilla.
Senator Robin Hood Padilla is recognized to explain his vote.
Maraming salamat po, Ginoong Pangulo. A'udhu billahi minasyaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Bismillahi wassalatu wassalamu ala rasulillahi. Assalamualaikum warahmatullah. Alam niyo po, ito na po siguro ang pinakamaligayang araw sa buhay ko sapagkat makasaysayan. Ako po ay nagpupugay at malalim na paghanga sa isinagawang paliwanagan ni Senator Marcoleta, Senator Soto, Senator Ontiveros, Senator Lacson, Senator Pangilinan, Senator Aquino, Senator Pia Alan Cayetano, Senator Rafi Erwin Tulfo, Senator Mig Subiri. Ang palitan ng mga paniniwala sa plenaryo ay simbolo ng humihinga at buhay na Senado. Nagagawa natin ang kalayaan at kasarinlan. Isang demokrasya na naririnig ang bawat naratibo. Tagahanga po ninyo ako lahat. At alam naman po ninyo, sa maiksing panahon ko rito, ako ay pro-Westminster. At ngayon, system po, system. Yan po yung parang sa UK. At yan po yung nakita ko ngayong araw na ito. Ang lahat ng mga senador ay gising, ang lahat ng mga senador ay nandito, ang lahat ng mga senador ay nagtatrabaho sa ayon sa kagustuhan kong makita ko ang bawat debate at ang bawat opinion ng bawat isa. Kaya nagpapasalamat po ako. Napakagandang araw po nito sa inyong lahat at sa ating lahat. Ngayon, mga kababayan, gusto ko pong malaman ninyo na ako po ay nagbibigay-pugay sa lahat ng nanonood sa atin ngayon. Malamang, ang sasabihin ninyo, siyempre si Robin Padilla, ang boto niyan, alam na natin. Eh, mabuti po, alam nyo na. Ang gusto ko lamang pong liwanagin ay ito. Ang nais ko, sana, ay katapusan na nito. Dismissal. Una pa lang po, bago pa lang po kami na-convene, labag na po sa kalooban ko na matuloy ito. Nakita nyo naman po, noong nagkasumpaan, talagang ipinaglalaban namin na politika ito. Politika ito At kailangan ng due process. Pero natuloy pa rin po, nag-convene pa rin. Pero hindi pa rin po ako nagsuot ng robe dahil para sa akin ay protesta. Dahil ayoko po talagang matuloy. Bakit? Sa loob po ng matagal na panahon ni Bonifacio, ni Aguinaldo, panahon ni Aguinaldo, ni Quezon, panahon ni Marcos Sr., ni Aquino Sr., ni Aquino Jr., ni Arroyo, Marcos Jr., PRRD Duterte, HOR ngayon, at Vice President Duterte. Hindi na po tayo natapos sa usapin ng politika at yaan po ay pinagtibay ng Supreme Court sa kanyang desisyon na sinabi niya mismo, oo, politikal ang impeachment, pero hindi kailanman dapat masagasaan nito ang karapatan ng tao. Malinaw at yun po ang pinaglalaban natin at kailangan dumaan sa tamang proseso. At yan po ang pinaglalaban natin. Ngayon, mga mahal kong kaibigan, pagkatapos po natin marinig ang bawat punto ng bawat isa, sana po matapos na po ito at harapin na po natin ang mga tunay na problema ng bayan. Katulad po ng sweldo, katulad po ng agrikultura, pagkain, kaguluhan sa West Philippine Sea, sa buong mundo. Ang dami po nating dapat pag-usapan. Total, meron pa naman pong Pebrero ang sinabi naman po ng Supreme Court at ang Supreme Court naman po, ang siya naman po dapat na sinasabi ng saligang batas. Malinaw po, matagal po akong ginawang chairman ng constitutional ni dating Pangulo Mig Subiri. Pinagkatiwalaan niya po tayo, pinag-aralan po natin yan at malinaw sa konstitusyon na ang magpapaliwanag ng saligang batas ay Supreme Court. Kaya sana po, ako'y malungkot talaga dahil napunta tayo sa archive. Yung archive, binasa ko pwede pala yan hukayin anytime, kung ano man. So, Hindi pa rin. Hindi pa rin tayo natapos. Kaya sana po, bagamat ang boto ko ay yes, aray. Gusto kong malaman at mailagay po sa lathalan ng Senado na ako'y may reserbasyon dyan. Malaking reserbasyon ko dahil gusto ko dismissal. Tapusin na natin to. Hindi pa tayo natapos eh. Total, nasabi na lahat. Oh, ilang oras ang banatan. Pero hindi pa rin natapos. Kaya po, mga mahal kong kababayan, bago po ako umupo, nais ko pong malaman ninyo na ang inyong Senado ay tumatakbo. Huwag po kayong malungkot sa mga hindi pabor sa amin o sa mga pabor naman. Isa lang po ang masasabi ko. Tigilan na natin ang politika at mahalin natin ang bawat isa, magkaisa na tayo, pag-usapan natin ang mga totoong problema. Maraming salamat po.
Thank you, Senator Robin Hood Padilla, Madam Secretary.
Senator Pangilinan.
Senator Francis Kiko Pangilinan is recognized to explain his vote.
This representation votes no. Unang-una, ang boto na no ay hindi nangangahulugan na hindi natin nirerespeto ang pasya o kapangyarihan ng Korte Suprema. Lalo-lalo na't hindi pa ito pinal. Wala sa hanay ng mga senador na bumoto ng no ang nagsasabi na hindi dapat respetuhin ang pasya ng Korte Suprema. Hintayin lang ang final decision. Kung tutuusin, kung hinintay lang natin ang final decision, hindi tayo nagpasya at wala tayong ginawa na mga hakbang out of respect dahil nga pending pa. Wala tayong nilabag sa pagiging immediately executory ng desisyon. Kaya kataka-taka kung bakit kailangan magkaroon ng archiving. Pero pasya ito ng mayorya. Mr. President, bumoto tayo ng no dahil naniniwala tayo. Mas mainam sana na hintayin nga ang resolusyon ng motion for reconsideration. Dagdag siyempre dyan ang pagkilala ng prinsipyo ng co-equality sa House of Representatives. Yung interchamber courtesy, yung pagbibigay galang sa isang co-equal, respeto sa isang co-equal. Kaya nais po sana nating i-lay muna yung matter on the table. To vote to archive the complaint despite the MR still pending, I believe, Mr. President, and I believe the others who voted no share this position, is premature, as the ruling may still be reversed or modified. In addition, at ito nga ang isang contention, to vote to archive the impeachment complaint, if at all, is to give the Senate the powers which are only reserved for the impeachment court, deciding, trying, and deciding impeachment cases. Precedents were cited in that the Senate and not the impeachment court acted on the impeachment cases of former President Estrada and Merceditas Gutierrez. But we submit, iba yung facts nung mga kaso na yun. In the Estrada case, supervening events led to the termination of the trial. In the case of Gutierrez, the Senate did not convene as an impeachment court. Kaya iba, apples to oranges, ika nga. We believe archiving the case is a matter exclusively within the powers and jurisdiction of the Senate Impeachment Court. Kaya lay on the table sana ang maayos na proseso under our rules. Allow me to reiterate that the final decision of the Supreme Court, yes, must be respected. The Supreme Court ruled that the impeachment court did not acquire jurisdiction, and its ruling rendered the official acts of convening as a court, of taking the oath, issuing of summons, and remanding the complaint as, for all intents and purposes, nullified. Kaya tinanong natin kanina, ano na ang nangyari sa constitutional duty and constitutional power as sole power to try and decide impeachment cases. We took an oath to uphold and defend the Constitution, and that includes our own determination whether or not the nullification of the acts of the impeachment court, an exclusive sole power to try and decide impeachment cases, if the ruling was based on the facts and not on a misappreciation of the facts. Kaya nga, sana hinintay ang motion for reconsideration. The impeachment court, being ousted of its jurisdiction by the Supreme Court, is unprecedented, based, and sadly, as we read the ruling, the decision, based on the wrong facts. It is disturbing. The distinguished minority leader pointed out, point for point, in his interpellation and manifestation, the errors in the facts that the Supreme Court based its findings of grave abuse. I reiterate, one cannot be right with the law if one is wrong with the facts. And that's why napakahalaga nung motion for reconsideration. There is still an opportunity for the errors to be corrected, kaya nandyan ang MR. And this is the reason why we voted no. Napaka-precedent setting nitong nawalan ng jurisdiksyon ang impeachment court, nawalan ng kapangyarihan o isinantabi ang kapangyarihan, sole power of the House of Representatives to initiate proceedings, at naway sa pamamagitan ng motion for reconsideration, mabalik yung ating kaninang nabanggit na ma-harmonize yung lahat ng mga constitutional provisions na hindi nag-aaway kung hindi lahat ay mabibigyan ng legal at binding effect. The power of judicial review, the sole power to initiate impeachment proceedings, and the sole power to try and decide cases of the Supreme Court, of the House of Representatives, and of the Senate. Maraming salamat.
Thank you, Senator Pangilinan. Mr. Secretary.
Senator Soto.
The minority leader is recognized to explain his vote.
Mr. President, I have more than expressed myself on this issue. Just in addition, a lingering question. How can the Senate archive something that is not before it? The articles are before the impeachment court. Therefore, I cast a negative vote.
Thank you, Minority Leader. Senator Soto.
Senator Tulfo Erwin.
Senator Erwin Tulfo is recognized to explain his vote.
Ginoong Pangulo, mga kapwa kong senador at sa sambayanang Pilipino. Bumoto po ako ng yes sa motion na sumasang-ayon sa desisyon ng Korte Suprema sa impeachment case laban kay Vice President Duterte. Ito po ay hindi sa gusto kong iligtas ang Vice Presidente, kundi dahil malinaw ang sinasabi ng ating batas at mas malinaw pa ang desisyon ng Korte Suprema na ito po ay labag sa konstitusyon. Alinsunod po sa one-year bar rule, hindi maaring magsampa muli ng impeachment complaint ng 1 taon matapos ang naunang reklamo. Ayon po sa kataas-taasang hukuman, ito ay nalabag. At bilang mambabatas, hindi ako pwedeng pumikit na lang sa harap ng isang tahasang paglabag sa ating saligang batas. At para saan o ano pa ang saysay ng panunumpa natin noong nakaraang linggo sa tungkulin na nakasaad doon na that I will protect and defend the Constitution kung ito ay susuwin lang naman natin. Ngunit linawin ko ito. Ang boto kong ito ay hindi para iabsuelto si VP Sara Duterte. Sa totoo lang po, gusto ko siyang humarap sa paglilitis upang maipaliwanag ang mga issue upang sumagot sa mga tanong ng taong bayan at upang harapin anumang pananagutan kung ito'y nararapat. Dahil ang paninilbihan sa taong bayan ay hindi po pribilehyo, kundi isa ring pananagutan. Public service is not just a privilege, rather it carries also huge responsibilities. Sa loob po ng mahabang panahon, nasanay na ang ilang matataas na opisyal kapag may kapangyarihan, may lusot. Kapag mataas ang posisyon, immune sa tanong o investigasyon. Tama na. Panahon nang baguhin ito. Kung tunay po na walang kasalanan si VP Duterte, dapat siya mismo ang manguna sa pagbubukas ng lahat ng dokumento, paggamit ng budget at mga hakbangin niya bilang pangalawang Pangulo at kalihim ng DepEd. Walang dahilan para umiwas kung malinis po ang konsensya. Ang boto kong yes ay hindi pagtatanggol sa kanya, kundi pagtatanggol sa legalidad ng proseso. Hindi po ito ang wakas. Kung may basihan at sa tamang panahon, hindi po ako magdadalawang isip na suportahang muli ang isang lehitimo at makatarungang impeachment. Dahil ang pamahalaan po ay para sa taong bayan, hindi po para sa iilang nasa puder. Maraming salamat at mabuhay po ang sambayanang Pilipino.
Maraming salamat, Senator Erwin Tulfo. Ginoong Sekretaryo.
Senator Tulfo, Rafi.
Senator Rafi Tulfo is hereby recognized to explain his vote.
Mr. President, my vote is yes. Let me explain my vote. My dear colleagues, in our Constitution, the sovereign Filipino people agreed to establish a government that will run our country. Malinaw dito kung ano ang kapangyarihan ng bawat sangay. Ang legislatura ang tagagawa ng mga batas. Ang ehekutibo ang tagapatupad ng batas. On the other hand, ang Korte Suprema naman ang taga-interpret o tagapaliwanag ng batas kapag may hindi malinaw dito o may pagtatalo kung paano ito ipapatupad. Kaya naman, ang respeto ng bawat sangay ng gobyerno sa isa't isa ay mahalaga upang tuloy-tuloy ang maayos na pagpapalakad ng ating gobyerno. Under the Constitution, it is the House of Representatives that shall have the exclusive power to initiate all cases of impeachment. Wala po tayo papel sa proseso na yan. Our role
only comes when a valid Articles of Impeachment complaint is filed before us. Mr. President, the case before the Supreme Court is about the impeachment initiation procedure before the House of Representatives. Whether a case of impeachment has been initiated according to the text and spirit of the Constitution. Of course, I will not delve into the correctness of the decision of the Supreme Court, but I believe it is within their authority to interpret the Constitution and declare whether the actions and processes before the House is constitutional. And so, we must accord the decision of the Supreme Court the same respect that they give the laws that we enact as the legislative. That is the scope and limitation of our powers. Having said that, allow me to go to the clear, dispositive portion of the decision. Sa dulo po ng 97-page decision, ito po ang sinabi ng ating Korte Suprema. Una, the Articles of Impeachment are unconstitutional and are deemed null and void ab initio. In other words, walang bisa nung simula pa lang. Second, the court said, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. Ibig sabihin, hindi nagkaroon ng Senado ng kapangyarihang maglitis bilang impeachment court. Mr. President, I agree that we should abide by the decision of the court to avoid any constitutional crisis. And if I were to take the duty to my heart, I believe the decision is very clear. No impeachment court was validly convened. That's my vote. With that said, however, there are concerns raised regarding the decision. So it is important for the Supreme Court to address these concerns. I have faith in the Supreme Court that it will perform its mandate. That's all. Thank you, Mr. President.
Thank you, Senator Rafi Tulfo. Secretary.
Senator Villanueva.
The Majority Leader recognizes Senator Villanueva.
Thank you very much, Mr. President. Mr. President, esteemed colleagues, this representation stands today not just a senator judge, but as a member of this institution who took an oath to uphold the Constitution. And I'm here, Mr. President, to explain my vote. But more importantly, to stay true to that oath, to serve with integrity and give life to the spirit of the law. Article 11, Section 1 of our Constitution provides that public office is a public trust. Ang isang katungkulan sa pamahalaan ay isang tiwalang ipinagkakaloob ng mamamayan. This underscores one of the core principles of democracy, that ultimate political power resides with the people. And thus, the preamble starts, Mr. President, we, the sovereign Filipino people, because the government's authority and legitimacy emanates from the people. Thomas Jefferson encapsulated the expectation from a person holding public office in one sentence. When a man assumes a public trust, he should consider himself as public property. Close quote. Kapalit ng tiwalang ipinagkakaloob ng bayan sa isang tao ay ang paglilingkod ng may katapatan sa saligang batas at sumasalamin sa mithiin ng bayan na nakapaloob dito. Ginoong Pangulo, pag-aari ka ng publiko dahil ang bawat galaw at desisyon mo ay hindi para sa sarili, kundi laging para sa bayan. While due process protects life, liberty, and property, public office is not private property. As Justice Malcolm wrote in Segovia versus Noel, a public position is not owned by its holder. Ang posisyon sa gobyerno ay hindi premyo o personal na karapatan. Ito po ay pananagutan at pagtitiwala ng taong bayan. During the July 26, 1986 discussion of the Constitutional Commission, it was noted that, and I quote, a violation of an oath of office is itself a violation of the Constitution because a public official's oath is in the Constitution. Close quote. Thus, accountability is not only a moral imperative, it is a constitutional duty. Public officials are answerable to the people at all times, and the mechanisms of impeachment and oversight exist precisely because no one can claim a vested personal entitlement to office. Where accountability is demanded, due process must still be observed. Ngunit, Ginoong Pangulo, hindi po ito dapat mamay-ari ang isang tungkulin pampubliko. Higit po sa lahat, hindi ito dapat maging kasangkapan upang takasan ang pananagutan. Wala po ni isa ang nakatataas sa pananagutan, nakakatakas sa pananagutan. Lalo na po ang mga nasa pinakamataas na posisyon ng ating bayan. Mabigat po ang papel natin dito sa Senado, Ginoong Pangulo, lalo na sa impeachment. Hindi po ito simpleng usaping legal. Desisyon po ito na nakabatay sa batas at nagmula rin sa ating prinsipyo at konsensya. The framers of our Constitution knew this. That's why impeachment decisions are ultimately acts of political and moral judgment, not just strict legal analysis. Kaya po malinaw ang disenyo ng ating saligang batas. Ang House ang may eksklusibong kapangyarihan para magpasimula ng impeachment, at ang Senado ang tanging may kapangyarihan na lumitis at magdesisyon. This is a sui generis role, unique, exemptional, and deeply rooted in our democratic system. That is also why both chambers of Congress were given the authority to craft their own rules of procedure in impeachment cases. May mga bumatikos po sa atin noon, Ginoong Pangulo, sa pag-remand natin ng Articles of Impeachment sa House. At sabi nila, ng mga bumabatikos, pag-iwas daw po ito sa tungkulin. Pero kung susuriin pong mabuti, Ginoong Pangulo, hindi po ito pag-atras sa ating tungkulin. It was a necessary and prudent step towards ensuring that the proper procedure was followed so that our decision as a court will not be marred by legal and constitutional infirmities. Now we are faced with the High Court's decision that tackles precisely that which we hope to avert when we remanded the Articles of Impeachment, Mr. President. So clearly today, the Supreme Court's decision in GR 278353 is a vindication of the Senate's action. We have been called so many names, Mr. President, and ridiculed in the digital court of public opinion. I'm sure the Senate President would likely agree with this representation that the allegations thrown at us regarding the impeachment and even the decision of the Supreme Court, a matter that we have no participation in, are extremely preposterous and absurd. But this exercise, while political in nature, is not about personalities. It's not about revenge. It's not about prevailing sentiments or personal biases. It is about upholding what is legal and constitutional and what will hold true in the years that follow. Let me make one thing clear to our kababayans, mahal nating mga kababayan. We in the Senate have never abandoned our mandate in this impeachment proceeding. Ang bawat hakbang po na ating tinahak ay nakaangkla sa kaluluwa ng ating bayan, ang ating inaalagaan at pinoprotektahan sa ligang batas ng Republika ng Pilipinas. But as they say, Mr. President, dissent is not a threat to democracy. It is essential to its survival. Kaya doon po sa mga pumuna, sa mga nagsabing mali ang naging pasya ng Senado, hindi tama ang ginawa po natin dito, naintindihan naman po natin sila kung saan sila nanggagaling. And in that same democratic spirit, I now take this opportunity to respectfully air my own dissent to certain portions of the Supreme Court's decision. While we respect the court's authority, I believe there are portions of the ruling that may have inadvertently made the already difficult process of impeachment even harder. Agree po ako doon, Ginoong Pangulo. Impeachment was never meant to be easy, but neither was it designed to be impossible. The framers of our Constitution deliberately relaxed the rules to empower the people and lower the barriers to initiating accountability against high-ranking officials. The Constitution even allows any ordinary citizen to file a verified complaint. Ang mababa at mataas na kapulungan ng Kongreso ang nagsisilbing takbuhan ng mamamayan sa mga pagkakataong wasak na ang tiwalang ipinagkaloob ng publiko sa mga inuluklok nito. And yet, Mr. President, with this decision, we now see new procedural hurdles that were not explicitly required by the Constitution, including the rigid interpretations of due process at the preliminary stage. These add layers of complication to a process that is already politically and institutionally fragile. Kung hindi po natin iingatan, tama po yun. Baka po mawalan ng saysay ang impeachment. Buhay sa papel, ngunit patay sa proseso. This was no accident of drafting, Mr. President. The framers of the 87 Constitution intentionally relaxed the requirements for initiating impeachment, lowering the vote needed from 2/3 as required in the past constitutions to just 1/3 of all House members. As explained by the framers of our Constitution, this was meant to I quote, make it easier, not harder, to hold high public officials accountable, close quote. They had lived through a time when power went unchecked and accountability was elusive. Kaya siniguro po nila na ang kapangyarihan ay laging may akaakibat na pananagutan. Mr. President, this representation did not come to this decision lightly. We understand and value the necessity of public accountability. Naiintindihan po natin yan. Napakahalaga po niyan. Walang sino man po ang dapat mailagay sa pedestal na hindi kayang abutin ng batas. Pero ang pananagutan po ay kailangan dumaan sa tamang proseso. Isang proseso na hindi lamang makatarungan, kundi naaayon at tumatalima sa saligang batas ng Republika ng Pilipinas. Sa mga ganito pong sitwasyon, hindi po naaalis sa aking isipan. Kung may mga pagkakataon meron po bang pagkakataon na maaaring labagin ng Senado ang mga ipinag-utos ng Korte Suprema? Maaaring halimbawa po nito ay kung may klarong panghihimasok sa internal rules of procedure ng Senado, ang Korte Suprema. Ngunit, Ginoong Pangulo, sa pagbibigay kahulugan sa nakasaad sa ating saligang batas, tanging Korte Suprema lamang ang may kapangyarihan bilang pinal na tagapagpasya. Article 8, Section 1 of the 87 Constitution expands the Supreme Court's scope of judicial power by mandating it to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. In the case of Angara versus Electoral Commission, Justice Jose P. Laurel, who later became the third President of the Republic, wrote, and I quote, "When the judiciary mediates to allocate constitutional boundaries, it does not assert any superiority over the other departments. It does not in reality nullify or invalidate an act of the legislature, but only asserts the solemn and sacred obligation assigned to it by the Constitution." Close quote. Noong pong tinatalakay ng ating mga constitutional framers ang probisyon sa Konstitusyon patungkol po sa proseso ng impeachment, binanggit po ng kagalang-galang na Commissioner Dodong Maambong ang isang sipi mula sa isang kaso sa Amerika. Ang sabi po niya, and I quote, "Ang impeachment ay ang unang hakbang sa isang proseso ng pagwawasto. Ang layunin po nito ay hindi personal na pagpaparusa sa nasasakdal, bagkos ang pangunahing layunin nito ay panatilihin ang pamahalaang naaayon sa konstitusyon." This quote captures the heart of what impeachment is meant to be, Mr. President. It is not about personalities or punishment. It is about protecting the very structure of our constitutional democracy. And sometimes protecting that structure means accepting limits, even when we disagree with how those limits are drawn. In this case, the Supreme Court, as the final interpreter of our laws, has spoken unanimously, and I will say it again, spoken unanimously, decisively, and with finality. It ruled that the impeachment complaint violated the one-year bar rule. The Vice President was denied due process, and that this Senate, as of the moment, had not acquired jurisdiction. Mr. President, in closing, again, I would say we may not agree with every word of that ruling. But the rule of law is not a matter of convenience. It is the foundation of our democracy. Upholding it, even when it is difficult or unpopular, is what gives this institution its credibility and our democracy its strength. To ignore it, no matter how justified we may feel, is to risk eroding the very foundation we are sworn to defend, our beloved Constitution. Kaya po, Ginoong Pangulo, sa liwanag ng ating saligang batas at bilang paggalang sa pasya ng Korte Suprema, habang kinikilala po natin na may nakabimbing motion for reconsideration na sinampa ng House of Representatives, and in adhering to the immediately executory decision rendered by the Supreme Court, I vote to transfer the Articles of Impeachment to the archives. Thank you, Mr. President.
Senator Villar Camille.
Senator Camille Villar is recognized. You may proceed, ma'am.
Mr. President, my dear colleagues, I vote yes to the motion to archive the Articles of Impeachment against Vice President Sara Duterte, respecting the decision of the Supreme Court. It is undeniable that the Supreme Court has the power under the Constitution to declare an act of a co-equal body as unconstitutional, a power known as judicial review. The power allows the Supreme Court to ensure that all branches of the government act within the bounds of the Constitution, and it should be respected. The three main branches of our government, the legislative, executive, and judicial, each is vested with distinct powers and functions by the Constitution, none superior to others. Each operates independently with its own sphere of authority and serves as a check and balance on the others to prevent abuse of power. This is the foundation of our democracy, and it ensures the rule of law, accountability, and protection of rights of all Filipinos. In this case, the Supreme Court has spoken. By a unanimous vote, the Supreme Court declared in clear and unequivocal terms the Articles of Impeachment against Vice President Sara Duterte unconstitutional and null and void ab initio for violating the one-year bar rule and due process clause. As a result, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. This decision, finally, is immediately executory. Mr. President, we have heard many good arguments in the recent weeks from both sides. Just today, being the youngest member of this robust body, I have learned so much from our esteemed and distinguished colleagues. But to me, it is simple. The opinion, or the most important opinion, is that of the final arbiter of our Constitution, and that is the Supreme Court. I have faith that the Supreme Court has done their duty and fulfilled their mandate. Being a legislator and a public servant, it is my duty to abide by that decision. Not too long ago, I took my oath of office as a senator, and I swore to support and defend the Constitution, and I adhere to that today. To do otherwise can lead to uncertainty and chaos, and even a constitutional crisis. This is what the rule of law expects from each and every one of us. And to respect the rule of law is to respect our democracy. And that is why I vote yes to the motion before us. Mr. President, dalangin ko sana na marisolba na natin ngayon ito upang mapagtuunan na natin ng pansin ang mga tunay at malalaking problema na hinaharap ng ating bansa at ng ating mga kababayan, katulad ng mataas na presyo ng bilihin, pagkaroon ng wastong hanap buhay, kalusugan at kaligtasan ng bawat Pilipino. Maraming salamat.
Thank you, Senator Villar.
Senator Villar Mark.
Senator Mark Villar is recognized. You may proceed, sir.
Thank you, Mr. President. I rise to vote yes and explain my vote on the matter before us, and to explain why we compromised today on archiving this very important topic But of course, we must always remember that the status quo is that the Senate has no jurisdiction. So in legal speak, this complaint is null and void. Last July 25, the Supreme Court rendered a unanimous decision declaring the articles of impeachment against Vice President Sara Duterte unconstitutional, noting that it is barred by the one-year rule under the Constitution and that it violates due process. The merits of this decision are not an issue before us. The sole question we need to answer is whether the Senate should respect the decision of the Supreme Court. And I say clearly and emphatically, yes. The Supreme Court has the ultimate authority to interpret what the Constitution is. No one, including the Senate, can substitute its opinion over the courts in any matter concerning the Constitution. And the Constitution itself, in Article 8, Section 1, entrenches the court's role in interpreting the Constitution and determining whether there has been a grave abuse of discretion amounting to lack or excess of jurisdiction by any branch or instrumentality of the government. This includes the Senate, even when acting as an impeachment tribunal. Justice Laurel laid down the doctrine in the Supreme Court as the final arbiter of constitutional issues in Angara versus Electoral Tribunal, where it was stated that when the judiciary mediates to allocate constitutional boundaries, it does not assert any superiority over the other departments. It does not in reality nullify or invalidate an act of the legislature, but only asserts the solemn and sacred obligation assigned to it by the Constitution to determine conflicting claims of authority under the Constitution. At dahil nagdesisyon na po ang Korte Suprema, tungkulin po ng Senado na sundin ang desisyon na ito. Sumasangayon man tayo o hindi, dahil nangako tayo, bawat isa sa ating mga senador, that we will support and defend the Constitution of the Republic of the Philippines, that we commit to obeying all laws and legal orders issued by the duly constituted authorities. Nasa oath of office po natin ito. In staying true to our oath of office, we must abide by the order of the duly constituted authority in matters of the Constitution, the Supreme Court. We must uphold the Constitution. Thus, the Senate cannot acquire jurisdiction to proceed with the trial, much less issue a verdict. Tulad ng sabi ni Senior Associate Justice Leonen, the impeachment process is a constitutional process. And although it is also a political process, it is not isolated from the requirements of the Constitution as a whole. Kailangan obserbahan ang due process, ang tama at makatarungang proseso bago matanggal sa posisyon ang isang individual. Habang iginagalang natin ang opinyon at pananaw ng bawat isa sa mga importanteng usapin, kailangan natin igalang, kilalanin at bigyang halaga ang kakayahan at kaalaman ng mga maestrado ng kataas-taasang hukuman na binigyan ng kapangyarihan ng ating konstitusyon bilang huling hukom na ipaliwanag kung ano ang batas at kahulugan nito at magdesisyon ng pinal sa isyung ukol sa konstitusyon. By recognizing the authority of the Supreme Court on the matter, the Senate does not abandon its mandate and its wisdom as an independent political body, nor does it concede or submit to a co-equal branch of the government. We are simply upholding the rule of law. At kung susuway tayo sa desisyon ng Supreme Court sa isang isyung konstitusyonal, binabaliwala natin ang konstitusyon. Ito ay magdudulot ng isang krisis sa ating saligang batas at lipunan na hindi makakabuti para sa taong bayan. As a functional society governed by the rule of law, we must accord our democratic institutions with respect, value their guidance, recognize their competence, and cherish their independence. Mr. President, pinapatunayan ng desisyon na ito na makakaasa ang tao na ang due process ay hindi lang guni-guni o kasabihan walang katuturan. Na ang due process ay para sa lahat at hindi lang para sa mga kakampi. Isang patunay na mapabisi presidente man o ordinaryong Pilipino, makakasigurado tayo na ang mga institusyon, ang Korte Suprema at ang Senado ay handang ipagtanggol, pahalagahan at bantayan ang ating mga karapatan. Without the rule of law, people may act without accountability, government leaders may act on personal interest, individual rights can no longer be guaranteed. Without the rule of law, there can be no justice, no order, and no real democracy. To end, I would like to quote Supreme Court Senior Associate Justice Leonen, who penned the decision. There is a right way to do the right thing at the right time. This is what the rule of just law means. This is what fairness or due process of law means, even for impeachment. Maraming salamat po.
Thank you, Senator Villar. Before recognizing Senator Zubiri, I'd like to thank him for his patience because he's always last whenever we do nominal voting. At some point in time, you might want to make a motion, Senator Zubiri, for us to draw lots on which letter of the alphabet we will start voting.
Thank you.
The gentleman may proceed.
Maraming salamat, Mr. President. Alam mo po yun, Ginoong Pangulo, dahil magkasama po tayo sa Kongreso ng 3 termino. At dun sa 3 termino, na alam ko yung bilang po natin ay 265, 268 congressmen, napakahirap po pag ang iyong pangalan ay nagsisimula sa letrang Z. Kasi ako po ay palaging huli. Minsan po, wala na pong tao nakikinig sa akin. Yung janitor na po, mga page ang nag-aayos ng mga upuan. Pero, subalit na yung araw na ito, nagpapasalamat ako at napakarami pang senador na nandito po na yun. Nandito si Senator Bato, Senator Bong, Senator Robin Padilla, Senator Amy, Senator Erwin, Senator Mark Villar. Our Senate President Pro Temp, who's not listening, but he's here with us today, together with the movant, Senator Marcoleta, and all the rest, no? Nandito ang 2 Cayetano na kaibigan natin. Yung mga seatmates nandito and minority. Pero Mr. President, honestly, it pains me to vote against my minority floor leader. It pained me and Senator Leonen. But what we are called to do here today goes beyond a simple vote. We all know that, Mr. President. It goes beyond a simple vote. Rather, for me, it's a test of our commitment to our Constitution and the rule of law. When the House of Representatives transmitted the articles of impeachment to us in February 5, 2025, my position was clear. We must go ahead with the trial, as this is our constitutional duty. In many interviews, that's what I said. It doesn't matter how I feel about it, because many people already said that I was on the other side. But I've said it doesn't matter what my personal feelings are. What matters is that we proceed with our constitutional duty. When the motion to remand the articles of impeachment came up on June 10, 2025, it was also my position, again, clear, that we must remand the articles not for the sake of dismissing the trial, Mr. President, but for the purpose of ensuring that the House of Representatives had not violated the impeachment process as laid out in the Constitution. I have always upheld the principles of rule of law and the primacy of the Constitution. And I've consistently shown the highest respects for the Supreme Court as the final arbiter of all constitutional questions. So today, again, my position is clear. We must respectfully adhere to the Court's ruling that the current impeachment complaint is unconstitutional. Our Constitution expressly empowers the Supreme Court to review even the article or the actions of political branches. In Francisco versus House of Representatives, that case which has been mentioned by almost all my colleagues here, the court affirmed that it is the final arbiter for constitutional questions with authority to strike down acts that violate the Constitution. Thus, I vote to support the Supreme Court on not to proceed with the trial of the articles of impeachment as it violates both the Constitution and the guarantees of due process, rendering the current complaint unconstitutional and void ab initio. The grave denial of due process only magnifies its fatal defect. Without jurisdiction, any trial would be meaningless and any verdict null and void, Mr. President. To disregard the court's unanimous ruling would be to invite a constitutional crisis and to break our oath to support and defend our Constitution. The power of impeachment is not without limits, Mr. President, my dear colleagues. It must be exercised within the boundaries set by the Constitution as interpreted by the Supreme Court. And let me be clear, for those listening tonight, the court did not place the Vice President beyond scrutiny. It simply required that any future impeachment follow constitutional safeguards. As simple as that. A new complaint may be filed by February 6, 2026, lawfully and with due process, at doon na po natin magagamit, Senator Kiko Pangilinan, yung ating mga gown at robe. Kasi sigurado, as the day will shine tomorrow, there will be an impeachment case filed against her. And we will be ready. This time, we will be prepared and follow the due process that was mentioned by the Supreme Court. I speak, Mr. President, as someone who's been a legislator for over 2 decades now, together with the Senate President, long enough to know that our fragile democracy rests on the strength of our laws, that our freedoms are given shape by our rules and traditions. And you all know me as a stickler for rules and traditions, together with my minority leader. I have served in both houses, House of Representatives and the Senate, and here in the Senate, being formerly a majority leader, the Senate President, and now your Deputy Minority Leader. In all these roles, Mr. President, I've been conscientious in adhering to the rules and traditions that protect the integrity of our beloved institution. It is in this spirit that I adhere to the court's decision. My vote today is based on the Supreme Court's decision last July 25, 2025, without prejudice to whatever resolution it may later render on the motion for consideration. That's why I thank the good movement, Mr. President, to allow me to amend or to allow the amendment of his motion to make it a mere archiving of the document, because that will never stop us from being able to pull out that document from the archives. Maraming salamat sa ating mahal na movement, si Senator Marcoleta. Let me just say this, Mr. President, to end my manifestation and my vote. Restraint is not weakness. It is obedience to constitutional order. Let us act not in defiance of, but in deference to the Constitution, to the Supreme Court, and to the people who have entrusted us these powers in this very chamber. Daghan kay salamat sa akong mga kaigsunan, and may God bless us all. Maraming salamat, Mr. President.
Thank you, Senator Zubiri. With 19 affirmative votes, 4 negative votes, 1 abstention, the motion of Senator Marcoleta, as amended by Senator Joel Villanueva, adhering to the immediately executory decision rendered by the Supreme Court en banc on July 25, 2025, which among others held that the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction, and to move to transfer the articles of impeachment in relation to case number 002-2011, entitled "In the Matter of the Impeachment Trial of Vice President Sara Duterte" to the archives. The same is hereby approved. Majority Leader.
Mr. President, Senator Bam Aquino would like to insert his explanation of vote into the record.
So inserted as requested by Senator Bam Aquino
And
into
together
the
with
records,
Senator J.V. Ejercito, Mr.
as well as that of Senator J.V. Ejercito. What is the pleasure of the Honorable Pangilinan?
Yes, just a parliamentary inquiry, Mr. President. If I recall, in previous votes, we first get the results of the vote before we go through an explanation of the vote. It seems like we have changed the process of voting.
That was upon the motion of Senator Zubiri earlier, which the chair explained before we put the matter to a vote.
I raised this question because, well, the reason why, at least the practice was, the votes first before the explanation is that at times when there are contentious voting, the quorum may suddenly disappear, or there will no longer be a quorum because of the long process of voting. So
The gentleman is correct unless a member asks that the procedure we just adopted is instead followed, and in this particular instance, the Honorable Zubiri moved without objection from any member, hence the procedure that we adopted.
Mr. President.
Senator Zubiri.
Therefore, that motion that I made was only for today.
Okay.
We can
That
go
is-
back to traditional practice.
That is the understanding.
Thank you very
You're
much,
correct,
Mr. President.
Senator Zubiri.
Thank you for the clarification, Mr. President, Mr. Majority Leader.
Majority Floor Leader.
Yes, Mr. President, some administrative matters, Mr. President. May I move, Mr. President, that we dispense with the reading of the journal of the 5th session, Tuesday, August 5, 2025, and consider the same as approved. So move, Mr. President.
Any objection? Hearing none, motion of the Majority Leader is approved.
Mr. President, with the consent of the body and noting that for some measures this shall lead to a third committee referral, and upon consultation with the minority and conformity of the chairperson of the Committee on Games and Amusement, I move for the secondary committee referral and or change of secondary committee referral as the case may be on the following measures concerning anti-online gambling to the Committee on Banks, Financial Institutions, and Currencies, while the prior secondary referrals will now be third committee referral. This is in view of the measure's implications on the financial and banking system, particularly with respect to fund transfers and other financial transactions associated with online gambling platforms. These are Senate Bill number 30, 47, 57, 142, proposed Senate Resolution number 12, proposed Senate Resolution number 19, and the privilege speech of Senator Zubiri delivered last July 30, 2025. I so move, Mr. President.
The understanding is the lead committee will still be the Committee on Games. The Majority Leader simply changed the secondary
Yes,
committees.
Mr. President, that is correct.
May we know if there is a third committee being referred to?
Majority Leader.
Sorry, what's the question?
If the third committee is Ways and Means, we have no problem with that. But if the third committee, as I read it, is the banks, that does not fall in the Rule 10, Section 15.
That's the second, Mr. President,
Second, not the third.
not
Your
the
Honor.
third.
So there are only two committees. Referral.
3, Mr. President.
3. What is the third?
The third is the Ways and Means, Mr.
Yeah,
President.
no problem with that. What about the others? I have a list here of your PS-19 and the privilege speech of Senator Zubiri referred to 3, 4?
Including the privilege speech, Mr. President, of Senator Mig Zubiri.
You are referring it to 4 committees?
3.
3 committees
only, Mr.
and not
President.
Ways and Means and
Banks and
not Ways and
Games
Means
and
or
Amusement,
Finance.
Mr. President.
Yeah,
Games
but
and Amusement
if
being
it's
the
not
lead
Ways and
committee,
Means
Mr.
or Finance and you go beyond 2, you refer it to the Committee on Rules. That's the procedure.
That's why, Mr.
Yes,
President,
not the
we
banks,
are.
not the committees.
Yes, Mr. President, that's the reason why we are asking the consent of the minority, Mr. President. If it is not okay with the minority, Mr. President, I will.
Your Honor, the reason why it's the Majority Leader that's making the motion with the consent of the body is precisely because the request for additional committees was referred to the Committee on Rules, and it's the Committee on Rules now acting on that request with the permission of the body, of course.
It is now the Committee on Rules asking for the permission
Yes,
because it was
that is
originally referred to you already.
Yes,
Yes,
Your
Mr.
Honor.
All right.
President.
And, we were not informed.
Thank you for your understanding, Your Honor.
I told you.
Any objection
I told you.
to the motion of the Majority Leader? There being none, motion is approved.
Mr. President,
Before recognizing the majority floor leader, Chair would like to correct the case number it mentioned earlier. The record should reflect that the motion pertained to case number 003-2025. The correction is so ordered to be reflected into the records. Majority Leader.
yes, Mr. President. Mr. President, at this juncture, I move that we adjourn the session until 3 o'clock in the afternoon of Monday, August 11, 2025.
Before
So,
acting on the motion of the Majority Leader, Chair would like to take this opportunity to thank the members of the Chamber, both majority and minority, for your presence, patience, forbearance, and magnanimity that we were able, in such a way that we were able to dispose and vote on this difficult matter of national interest in the most pleasant manner, form, shape, and size. Thank you very much. Is there any objection to the motion to adjourn? Hearing none, session is hereby adjourned until 3 o'clock in the afternoon of Monday, 11 August 2025. Thank you once again. Good evening.
thank you, Mr. President.
Thank you, Mr. President. If the distinguished gentleman from Tarlac favor me with a few questions, I will be gladly accepting his favor. And if the Senate President will allow me, after a few questions, I will make my own manifestation to that effect.
The gentleman may proceed, should Senator Marcoleta so allow it.
Yes, Mr. President.
Thank you, Your Honor. Thank you very much. Mr. President, thank you. So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR, or the motion for reconsideration filed last Monday by the House of Representatives. Is it not, Your Honor?
The question whether is it
Yes, your
subject
basis
to
for
appeal?
your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor, that's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final, thus appealable. Ngayon, naka-apila na. Marami nagtatanong kung naka-apila na, ba't tayo nagmamadali? I-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo po, palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn eh. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo, meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babaligtarin po nila yung kanyang sarili. Kaya, napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone, the reversal of the Supreme Court's own decision is not impossible, even in landmark cases.